Before this courtroom hearing even begins, tensions are already running high. A defendant stands before the judge accused of violating probation multiple times, missing required appointments, failing to complete community service, and ignoring a strict zero-tolerance order. But the twist: she admits to everything. What unfolds next is not just a simple violation. Hearing it becomes a tense courtroom clash about responsibility, excuses, and credibility. The judge appears determined to find a path that keeps her out of jail. But the more she talks, the more the situation spirals. Will she convince the court she deserves another chance, or will her own words seal her fate? Let's watch this moment carefully, because in court, what you say and how you say it can change everything.
That set of facts you just provided is the basis for your statement that you were denied a fair hearing?
It was at this moment that she knew. She fucked up.
Yeah, that I was I could sit there and wait, I guess however long it would have taken. I was there almost 4 months.
You were in on 4 months without a hearing?
Yeah, I was there for 4 months. I didn't have a hearing.
That sounds extraordinary.
Well, I didn't have a hearing. I just was given the recommendation, and I was told either I could take it or not. But I could get out that day if I took it. So against my better judgment, I didn't want to take it because it was extensive, knowing I didn't have a job and wasn't going to have a job for a while. So I just bit the bullet and took it so I could get out and get back under doctor's care.
Okay, but that sounds like a strategic decision you made. That doesn't feel like somebody has said something that denies you a fund.
Well, no, I didn't say I was denied one. I was just saying I didn't have a hearing.
You said you were denied access to a fair hearing. I mean, we can have Terry quote it back, but I mean, you said you were denied access to a fair hearing.
What I meant was I didn't have a hearing before I was given that recommendation.
I mean, because what I just heard was that as a courtesy to you, they pulled you early and offered you a consent order.
Yeah, that's because they weren't, I had to give an MRI for my foot. And
at this point, the defendant begins explaining her situation: medical problems, surgery, financial hardship, and even selling her car just to get money together. Now, situations like this can sometimes influence how a judge approaches probation violations. Courts often consider legitimate hardships, especially medical issues. But here's the key legal moment. She already admitted to the violations earlier in the hearing. Once those admissions are on record, the judge isn't deciding whether the violations happened. The judge is deciding what the consequences should be. That means her credibility and attitude toward responsibility become incredibly important. So here's a question for you. If you were the judge, would these circumstances make you more sympathetic? Or would you still focus on the missed obligations?
they sent me to the hospital and my insurance wouldn't pay for it. So that next morning actually is whenever I was given this recommendation to get out. And I'm still under care of my surgeon. She hasn't released me yet to be able to walk back on my foot fully yet.
I mean, you're coming in here, but I need to say out loud, these are not nothing cases. 25 SR 837 is a battery family violence.
Right.
It's one of the highest, please don't interrupt me. It's one of the highest cases that we have. 25 SR 846 is a simple battery under the Family Violence Act, which is also one of the more serious cases in this court.
Well, if you look at my record, I haven't had any charges, or I haven't never been convicted of any simple battery. The last time I was charged with that was the last time I was married. I've been divorced since November 27th, 2011. I haven't had any charges, and honestly, this relationship I've been in has been abusive for the last 10 years, and that was the first time I called the police on him, and then I ended up going.
Okay.
I mean, you can look at my criminal record and see that I'm not a battery person. I haven't never been convicted of any battery at all. And now this has caught me at a really bad time to where I can't, do anything to help myself in this situation, and I don't have anybody to turn to help me with money. And if I have to go, if I could please, possibly go on the weekends so I could still get to my doctor's appointments.
Okay. All right. Ma'am, anything else you want to tell me?
I'm just worried if I have to go, what am I supposed to do? Like, I won't be able to get to my doctor, so how am I going to be able to know about the condition of my foot? And
This is a critical turning point in the hearing. The judge is now challenging her claim that she was denied a fair hearing. From the court's perspective, the timeline and documents don't seem to support what she's describing. In courtrooms, documentation is everything records. Warrants, signed orders, and legal representation all become part of the official story. When a judge starts referencing paperwork directly, it usually means they're testing the credibility of the person speaking. And right now, the judge clearly feels the story doesn't fully add up. Moments like this can dramatically shift a judge's perception. The question becomes, is the defendant explaining her circumstances? Or is the court hearing excuses instead of accountability?
Spalding County inmates are provided medical care.
yeah, I'm well aware of that.
Okay. Anything else, ma'am?
No, sir.
Okay. So the evidence is closed. Ms. Pluckett, what I need you to know and why you're sensing like frustration from me is I kept waiting to hear you accept any level of responsibility. And I heard no.
Well, I'm sorry.
I gave you a full hearing. I circled back to you on several occasions and said, is there anything else you want me to know? So that was not an invitation, ma'am, for you to interrupt me and tell me your opinion about my opinion. Your opinion of my opinion is irrelevant to me. Are we clear?
Yes, sir.
So I'm going to be quiet now, and you're going to tell me all the rest of the stuff you need to tell me, and then I'm going to talk. Go ahead.
I'm just nervous. I apologize. I don't really know what else to say right now.
Okay. Anything else you want to say before I start talking and you agree not to interrupt me?
I just put myself on the mercy of the court.
Okay. Last chance. Anything else?
And I'll take full responsibility for everything that was said. I didn't mean to ignore that or put that off. I'm just nervous. I'm sorry.
Okay. All right. Anything else before I do my talking?
No, sir.
Okay. So now you're going to be quiet and I'm going to talk. Fair enough?
Mm-hmm.
All right. That was a yes.
Yes, sir.
Okay. I kept waiting for her to accept responsibility for anything. I mean, she did admit to the violations, but I kept waiting to hear how she was going to make these things right. And instead, I heard a litany of that she was denied access to a fair hearing, she was called up and caught off guard, and I'm looking at these documents. So each time you're referencing an event that happened in your life, there was a piece of paperwork that was created from that event. And I'm looking at it. And I'm looking at that you were represented in this case. You were represented when you entered this plea. And in both cases, and I'm addressing both cases. I'm just addressing both cases. Oh, you want to talk again? You go right ahead, ma'am. This is clearly your turn to talk. Go ahead.
I'm sorry.
No, say whatever it is you want to say. You clearly need me to understand something that you don't think I understand.
I apologize, Your Honor.
No, go ahead. I will wait.
I just keep messing up. I'm sorry.
Yeah. That's exactly what is happening here because I have spent this whole morning, at every break, looking at your case and trying desperately to find a way not to go to jail. I need you to understand that since 9 o'clock this morning, I have looked at your case no less than 3 times, trying to find a pathway for me to feel comfortable as the judge of this court to not put you in jail. And I was desperately hoping you were going to come in here and say from the very beginning, I have full responsibility here. I did not do the things I should have done. I understand that I have responsibilities here that I didn't do. But I heard you repeatedly say that we're trying to get money out of you that you didn't have. Well, we're a $0 court. everybody in this court, except restitution, can work off their fines with community service work, or is unable to work can get their fees waived. Everyone here who has medical issues, we deal with that. We know what to do with that. We know how to help people. We have all kinds of folks who come in here and do their community service work in the very comfortable chairs in the back because they can't go do physical labor. We meet people where they are. And for you to come in here and say that you are denied access to this court because you are caught off guard is disingenuous on its best day, because what I heard was, as a courtesy to you and out of respect for the fact that you were incarcerated, you were given an opportunity to sign a consent order back on November 20th or somewhere there close to. The warrant, which you said you were incarcerated for 4 months, that makes no sense to me at all, because the warrant that was issued, that you signed the consent order on, was issued on October 8th of 2025, and the consent order was signed a month and 12 days later on November 20th. So this fact that you stayed incarcerated for 4 months, it doesn't even exist in my file. The list of... Go ahead. Go ahead. Go ahead. What is it you want me to know?
I forgot about the warrant.
Now we're seeing the judge openly explain something many viewers might not realize happens behind the scenes. Judges often review cases multiple times before making a final decision, especially when someone's freedom is on the line. In this moment, the judge is saying he actually spent the entire morning trying to find a legal pathway that would allow the defendant to avoid jail. But from his perspective, the turning point wasn't just the violations, it was the lack of clear accountability. In probation hearings, admitting mistakes and showing a plan to correct them can sometimes change outcomes dramatically. Instead, the judge feels he heard repeated explanations about circumstances rather than responsibility, and that frustration is now becoming very clear.
That had something to do, I don't remember exactly, but that was lifted. Something to do with Miss Rich. I don't remember the whole spiel of it, and I'm sorry. I'm so nervous. I'm just messing up. I just need to be quiet.
To be fair, that is exactly what I asked you to do.
Yes, sir.
If I might just be very clear, I gave you all the time you wanted to speak, and then I asked you to be quiet and let me speak, and you have utterly failed to do that at every turn. I don't see you as a candidate for probation. I don't see any pathway where this gets any better. I don't see any pathway where this works. And given the fact that this is not the first warrant on this case, and it's getting worse, I don't think this is...
And just like that, the judge reaches his final decision, revoking probation and sending the defendant to jail. From a legal standpoint, this outcome comes down to several key factors: admitted probation violations, prior warrants in the case history, and the judge's conclusion that probation was no longer working. But what makes this moment so striking is the judge's own words. He openly says he was looking for a reason not to send her to jail. Ultimately, he felt the court couldn't continue the probation relationship. Cases like this highlight how critical accountability, communication, and credibility can be in a courtroom setting. Now, we want to hear from you. Do you think the judge made the right decision here? Or should the defendant have been given another chance? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.